Hi, this is Blaine Cluten for Cluten Law. Answering the question today, do lawyers lie about settlements? Now, I'm an attorney, and I suppose that it's going to seem a little bit biased if I'm answering this question about whether attorneys lie about settlements, but let me see if I can demystify this a little bit. So there's different aspects to a settlement, and I'm assuming that this question is in response to a personal injury recovery or wrongful death recovery or some other contingency fee agreement type case. So in the context of an attorney first meeting with a client, and the question is, are the attorneys going to lie about other cases that they've had or lie about the chances of recovery? In my experience and part of the different organizations that I'm involved with and a lot of the attorneys that I've talked to, most attorneys do not oversell cases on the front end to potential clients. That's just been my personal experience. Usually they're going to talk about the issues with the case. We might refer to them as the warts of the case. But they're going to be fairly upfront with the client about these are the issues that are going to impact recovery. But it's going to depend on the attorney. I mean, there are certainly in every profession and every walk of life, there are going to be attorneys that are going to use a certain amount of, in advertising, the term is puffery in order to obtain the client that they're trying to get. So I know that this does exist. I'm not trying to pretend that it doesn't, but we do need to distinguish the difference between how much the attorney is advocating for themselves and what they're saying specifically about the case. Now, the second part about lying about settlements, I've had cases where, as part of the settlement agreement with the defendant in the case, or defendants, there is a settlement agreement that calls for a confidentiality clause. And that impacts all the parties and then the parties to the case, including the attorneys, that the attorneys cannot talk about the terms of the settlement agreement. And while the attorney may want to talk about the case and the different aspects that they've either won on or that there was issues with, very specifically, there are terms that are just not going to be able to be discussed with potential clients, the media, anybody. So it may seem as if the attorney is being cagey about past cases that they've had that may be very similar to the situation that the potential client is in. But this could be due to the fact that there is a confidentiality agreement that prevents the attorney from talking about it. And I'm not doing this to say that an attorney may not use this as an excuse and may not make it sound as if the recovery was much, much greater. I'm not saying that they can't put a spin on it. I'm just saying that when it comes down to it, and if I'm talking to a client and I want to talk about what the settlements were, I can only speak in, sometimes it seems like I'm being very vague and mysterious. And I'm not intending to be. I want to be a straight shooter and help them understand, but I must follow the settlement agreement. And that's beholden to my duties of ethics and the client that I was representing in the past, which is I still maintain that those certain requirements, those ethical requirements that I must follow those responsibilities. Do attorneys lie about settlement? So I think that those are going to be the main things, is whether they're going to seem like they're puffing up the case when you first meet with them. I suppose that the last thing that I would talk about is once the settlements come in, and so at this point you've retained an attorney and you've gone through the case. If an agreement is reached, you're going to have likely a settlement agreement up front that says something to the effect of the attorney's going to get paid back for their expenses before you get your recovery. So those expenses are going to come off the top before they start divvying up the rest of the pie. Now, that can seem sometimes a little bit troubling or a little bit difficult to understand because, and you'll hear attorneys say a lot, I'm not an accountant, not a numbers guy, which is funny because they're not numbers guys until they start talking numbers to settle a case. I suppose that's neither here nor there. But I don't think it's unfair to demand an accounting and to sit down with the client at the time of settlement and explain all those specific fees that are coming out of the top, because that is affecting the client's recovery. That is something that I do in my practice. Is I sit down with my client, I go through every line item that they want to. I have it as a printout that they can take home with them, and then they can bring it back and ask me any questions about line item costs that are coming out of those fees. But I'm doing that in an effort to be as transparent as possible. And I really do think that most attorneys probably have some sort of similar practice to this. So I don't think I'm unique in this respect. But then the remainder, what's left over after those fees are taken out, is simply that agreed upon amount that was discussed at the beginning, that contingency fee. So most often it's going to be that 33%. Certainly can be lower, can be higher, but most often it's going to be right around that 33%, so that the client's taking the 66% of the remainder after those fees are deducted, and the attorney's taking the 33% after those fees are deducted. So that's the kind of the last idea or the last thought that I had on lying about settlements. I hope that this answers a little bit better. As I mentioned, I don't know that there's going to be a person that's in a much better position to help explain whether attorneys are lying about settlements. I suppose then maybe clients can talk about their specific experiences with an attorney, but I think that it becomes a little bit challenging because the question itself can go in so many different directions. And I think that the most important thing, I guess the takeaway that I'd like to give is that the best thing that you can do as a client, and if you have questions like this, is to continue to ask probing questions when you're initially meeting with the attorney so that you're really understanding. Most attorneys do want to explain themselves so that there's no question about what kinds of cases they do, what kind of recovery you're looking at. But to the extent that you still have questions in your mind, you should continue asking those questions until you feel satisfied with the answers that you're getting. And part of this is going to be planning on the client side to make sure that they're meeting with attorneys early in their case, that right after they realize that they have a case that's worth bringing, that they're meeting with attorneys so that they're not missing out on some time-barred limitations, and that they're able to recover as much of the evidence as possible to help their case, because those are going to be the limitations that the longer that a client waits to get that case going, that's going to start to affect the recovery in a case. Thank you for listening, and again, hoping that I've been able to demystify this area a little bit. Blaine Cluten for Cluten Law. Thank you.